I guess we'll go ahead and get started. We'll go over some house rules and some of the details before we kick off the webinar. Hello, everyone. My name is Joanne Rash. I'm the acting chair of the California chapter for the Textile Chemists Association. And today we are lucky to have a presentation from the U.S. Patent Office. We have with us today Jara Edwards. Thank you so much for being here. And she's customized the presentation on a background on intellectual property and some specifics for the textiles and clothing industry. We ask that everybody keeps themselves on mute throughout the presentation, but using the chat feature, you can ask your questions. If they're clarifying questions, I can ask Jara and I'll be fielding the questions. If they're discussion questions, we're going to hold them to the end. So the final 15 minutes, there's some opportunity where we can take ourselves off mute. It's a small enough group where we could really make it a conversation and really ask questions and get any clarity that we need to learn about the intellectual property of textiles and clothing. So with that being said, I welcome everybody today. And Jara, if you want to go ahead and share your screen. I'm here and I'll be watching the chat for you.
Thank you, Joanne. So let's see, I should be sharing now. Hopefully that is working. The Teams window disappears when I go into full screen mode. So please let me know if you cannot see our very bright slide presentation.
Everything looks good. Thank you.
Okay, great. All right, so as we know, I'm here from the USPTO, and I'm Jara Edwards. I'm a supervisory patent examiner here in our San Jose office, and currently acting assistant regional director for this office. And today I'm going to do just an overview of intellectual property as it relates to textile chemistry, and also tell you about some of the resources that we have that are all, no-cost services that the PTO offers, mainly for educational and, helping solo inventors and that sort of thing. We have a lot of resources for that. So. I'm going to start off just with some sort of interesting statistics. You can see, patent growth over time. I think this graph ends somewhere around 2017, but we're definitely seeing an increase in the number of filings over time. I think it took about, 150 years to get to 5 million patents, and now we're well over, I think, 11 million. And we've done in about 25 years what it took previously, 150 years to do as far as patent filings. I apologize, there's a very busy road right next to my office if you're hearing a siren, just a fire truck going by. So we're definitely seeing an uptick in applications over time, which is great for us at the patent office, keeps us busy. So this information is actually for wearable tech. This is part of what I presented at the WEAR conference a while ago. And we don't have the same statistics, unfortunately, specifically for textile or textile chemistry. But you can see that, the wearable tech business is really outpacing just generally, the rise in filings. I mean, there's a really big uptick there in 2016. And I think that relates, though, to just generally textiles and textile chemistry, because, for all of this wearable tech, at the base of that is, the textiles that the sensors and whatever else are attached to. So with that increase, I mean, we're certainly seeing increases in related technologies as well. So here at the Patent Office, as far as patent examiners, we're divided into what we call technology centers. And so this slide shows about how many art units, basically technology for smart fabrics might find, the placement of that technology in the office would be in a lot of different technology centers. So this wouldn't necessarily be that, one invention is spread across. This is different applications are spread across our technology centers. So 1600 and 1700 include examiners that mainly focus on chemistry and material science. And 2600 and 2800 are communications and that sort of technology. And then 3600 and 3700 are more manufacturing and those sorts of technologies. So you can see for smart fabrics, I mean, that spans the whole gamut of technology centers. And each art unit would probably have somewhere between 15 and 30 examiners usually. There are some super art units that have up to 100 examiners, but you can see, there's some areas where they might receive more applications from that technology. So that's kind of what that graph is showing. So how do we organize, the patents themselves? It's similar to like a Dewey Decimal System. We use something called the Cooperative Patent Classification System. And so this just kind of gives you an idea of the overall general categories. There are many, many subcategories within each of these. But you can see it tries to follow industry and sort of existing practices and technologies. It's not a theoretical exercise in different aspects of science. It really is organized by how do people practically use this technology. So, human necessities, I mean, it's arguable what's a necessity, right? Some people may say, oh, well, my smartphone's a necessity. According to the CPC, that's not necessarily the case, but that's, surgery, food, clothing, things that, sort of maybe there's a little more universal agreement that, we really need those things. But actually gaming, I think, gaming and entertainment is under human necessities. So there's a little wiggle room there on opinions. But some of these other categories are very broad, but you can see there's one for chemistry, which obviously a lot of the technology for fabric coloring and fabric chemistry is going to fall in there. And then there's also a separate category for textiles. So when we're classifying inventions, sometimes one patent application may relate to, 3 or 4 of these categories. And so when we're doing the classification, any of them that are relevant to that application will be applied to that application. So you'll find that applications will have sometimes 20 or 100 different classifications to describe, everything that's in that application. And we'll see a little more later in the slideshow. So this just gives a little more detail about what you'll find under those different classifications. So for example, the category G, I think that was physics in the overall classification. And usually there's a number and then another letter, and that's sort of the third indentation. So under that, there's technology for different devices for identifying and color matching and calibration of those devices. And that's relevant for textile coloring and chemistry. That area seemed to come up a lot in terms of, analyzing and making sure things are to a particular standard. And so you'll find a lot of devices and processes in that area. And then, some other areas that definitely are relevant are treatment of fibers. And you can see it's broken down different ways based on, what the treatment is, what the fiber is, sometimes by the application. And then there's also detergents, organic dyes, and dyeing and printing of textiles. And this is kind of the same thing. This just has even more detail to give you an idea. When an examiner is looking, what's relevant, what's a relevant area that I might want to look for prior art based on this application. It kind of gives you an idea of the level of division that's available in that classification system. So sometimes it's very specific, like for dyes, you know, it goes into great detail about these specific kinds of dyes. And sometimes it's much more general. This doesn't mean too much. I mean, this is just showing the same thing for, you know, the more the textile chemistry applications. They would mainly go to 16 and 1700, which are our chemistry related areas, and then 36 and 3700, which are more mechanical processes. So these are some images of patent figures, and this one is the front page of the patent, that are related to textile chemistry. So this is and I'm probably going to butcher this word, spectrophotometer. And so this is an idea of, you know, what you might see in a figure in a patent or a patent application, kind of indicating, you know, what the device is that was invented. And I included this front page because sometimes there are no drawings. So this, you can see, it's for a process of treating garments. And sometimes there'll be a flow chart or something that they'll include as a drawing, but sometimes they'll just describe the process. So there really aren't any drawings to illustrate that. And that often happens in chemistry applications too, where there's not necessarily a drawing to show, you know, the compound. There may be some structures that are figures within the patent, but there aren't really going to be drawings. And then I also noticed on here a lot of the publications that are cited, which every patent that's issued will have a list of publications that the examiner considered when they were issuing the patent. But you can see there's some AATCC symposiums and publications. So, you know, your organization creates a lot of prior art and relevant documents to these patent applications. And then this last example just shows, so one application really can have many different aspects of an invention. So this is for retro-reflective fabric. And this first figure is showing the machine that applies a coating of a material to create that fabric. There's another figure that's more closely showing the application of that to the fabric. And then there's sort of the end product. Here's the garment that would be using that fabric. Now, all of that may not remain within one patent. Sometimes during what we call patent prosecution, when we're examining the patent at the office, we may end up dividing something. If there are too many inventions in one application, then they may have to file a second application so that each patent is really focused on one invention. So that's, you know, sort of a little overview of things related more closely to textile chemistry. But I guess I'll pause here to see, you know, if there are any initial questions, but I'm about to go into more of just an overview of intellectual property and what some of the terms mean, and then a little more detail about patents. So I can't actually see the chat or anything right now.
I don't see any
okay.
comments or questions in the chat.
Okay, great. Then I will just continue. So there are different types of patents. As you can see here, utility patents are usually what we think of when we talk about patents. And utility patents are for, as I kind of mentioned along the way, you can patent a process, you can patent, you know, a machine, a product that, you know, a machine makes or a process makes. Those are sort of the main types of utility inventions that you'll see in utility patents. There are also design patents. So design patents only cover the look of something. So a design patent wouldn't be a process. It would only be, you know, sort of that ornamental aspect of whatever you know, was being invented. So often products may have a utility patent and a design patent. The utility patent for what it, you know, does, or some function of the device, and then the design patent for just that, you know, look of the device. And then that same, invention or product may also have trademark protection, because trademark protection really is to identify the source of the goods. And so there may be a logo, or there may be distinctive packaging or something like that. That's also part of trademark protection. So copyright is more for what we think of as, artistic endeavors. So, it lists here like books, photos, music, films, that sort of thing. Also, the actual coding of a computer program can be copywritten. And so there's, for some products that, especially those that incorporate some type of computer programming, there could also be a copyright on, that same invention or family of inventions. And then trade secrets are also still an option as far as intellectual property protection. And just like it sounds like, that's something that does not become public, and that you would not file anything with the patent office to protect your trade secret. To protect your trade secret, you just keep that secret. You keep that to people who need to know in order to, create that product or make that service, and you have to take steps to protect that from becoming well-known information. So, some of the most common examples are the 14 spices and herbs of KFC, and the formula for Coca-Cola, that sort of thing. Definitely want to keep that a trade secret. And I'll just mention that different protections. So utility patents, you receive that patent for 20 years from the filing date. Design patents is a little bit shorter, only 15 years. And I believe that's from the date of issue. Copyrights last much longer. For some works, it's 95 years from publication, others 120 years from creation, and then others life of the author plus 70 years. So that's quite a bit longer than patents. Trade secrets, as long as you can keep it secret, that's your protection. And then trademarks, again, because they're tied to actual use in trade, as long as you continue to create those products and sell those in the open market, then your mark is in continuous use. If you do register it, you can renew it. And so there's some information about the times that you would renew that application. And trademarks don't necessarily have to be registered, but there are some benefits that make them easier to enforce when they are registered. So for example, if you did have to, sue someone for infringing on your trademark, if you have it registered, then that, makes that process a little easier. Also for stopping, fakes from being imported from another country. Border Patrol will actually help with some of that enforcement if you do have a registered trademark. And so that's just showing, some more examples. So this design patent, this is not for, not sure what that was. It's not for any function of the guitar. It's just for, this look, this curved exterior, maybe the placement of where the buttons are and that sort of thing, that overall look of the guitar. And then, music for the copyright. Utility patents, we'll talk a little bit more about the different categories for utility patents, but that's again for, the function of the device itself. And so here's one of those examples where, many different types of intellectual property protection apply. You have trademarks for, the company name, so Apple, and even the specific model. For the software that's on the phone, may be protected by trademark. And then for patents, there's the data processing methods, the different chips, and, other constructional aspects of it. There's, the coatings and paints, the chemical compounds. Maybe there's some properties for those that, patent protection is sought for, and, the other parts of the phone. So there could be a lot of, utility patents on something like a mobile phone. Again, with copyrights, that's maybe the software code, instruction manual, and then the ringtone as as a work of art as a musical ringtone could have copyright protection. Trade secrets, only Apple knows. we can't list those here because they're secret. And then designs. So the shape, the outer shape of the phone, the look of different features. The sort of divot here, the placement of the buttons. Not sure why this error is popping up. That overall look is something that would be something you could protect with a design patent. And so again, with trademarks, why use a trademark? You could just, sort of sell your goods. You don't have to have a trademark. But having it is helpful as far as recognizing, again, the source of the good. So this is your brand. Maybe you have a certain standard, and that's why your product is superior. And so you want people to know this came from, this particular source. You can rely on, my high standards in producing it. And sort of protect your ability to get customers based on that. Also, enforcing and bringing actions if there are people who try to make a fake product or try to use your trademark without your permission. Registering the trademark is helpful with that. And also, if you do want to start selling in a foreign country, having it registered in the US can be the basis for your foreign filing. And also to put others on notice that you've registered the trademark. Now for patents, so this describes a little more specifically what exactly a patent is. Because one thing that people don't realize sometimes is that a patent doesn't actually give you a right to do anything in particular, but it does give you a right to exclude others from, as listed here, making, selling, offering for sale, or importing the claimed invention. Now, the reason it doesn't really necessarily give you a right to make, like, it's not that the patent gives you a right to make the invention, is that there may be some aspect of your invention that's covered by someone else's patent. And so maybe in order to actually sell that, you would have to get a license or make some agreement with some other party to ensure that you're not infringing on their patent by selling, your device. And that's not always clear where the line is. And so, it's important to understand that what the patent really gives you is that right to exclude others. It is for a limited term, so like 20 years from the date of application, and that's a public interest-based limit, so that once that term is over, then this technology is now in the public purview. Others can benefit from that knowledge being made public. And just to keep in mind, there is no worldwide patent. Patent protection is, based on separate jurisdictions. So there's, patents granted by the USPTO cover the United States. And if you want patent protection in another country, you would have to file for protection separately in that country with that country's patent authority. And this talks a little bit more about, the benefit, ensuring that there's this balance of, whoever filed for the patent and the owner of the patent has a certain amount of time to get their own personal benefit from that, sell their product, build their company, benefit from that intellectual property. But also, when that term ends, then the public has a right to benefit from that. And that knowledge will be, secured, and there's a standard when you're applying that you have to make what your invention is clear so that others can follow sort of the directions or the blueprint that you've provided in your patent. You have to explain things clearly enough that other people can use that information to actually do what you're describing. And so why get a patent? Again, particularly if you've invented something that you want to sell, obviously that can help you gain entry into the market. If you're going on Shark Tank, I know there's always people on Shark Tank who say patent pending, which just means they filed an application. It doesn't necessarily mean that they're going to get a patent, but that can help you, bring investors to your business. So it's a great marketing tool. Also, if you've got this great idea and it's something that maybe is, it's possible to reverse engineer it once you start selling it, then you may have competitors that will, start trying to make that same product for cheaper. Well, if you were able to get a patent on it, then you can stop that and ensure that, your market share is coming to your company. And also collateral for funding and creating revenue, a lot of business benefits from obtaining a patent. And then if we talked about before, the benefits to the public, research and development, strengthens the national economy. And the example that's often given is with medicine. So you can patent, a medical formula, but after that 20 years, it becomes available. And that's usually when a generic version of that medicine will become available. And that usually is a lot less expensive maybe than the brand version was. So that benefits the public because now we have this great, improved medication. And since it's now, sort of in the public domain, it can be made much less expensive. So that's kind of recapping what we've already said. And so I'll pause here, see if there were any questions. This gets a little more into detail about the different kinds of utility patents, but if there are any questions, we can.
Still seeing none, but I definitely want to encourage everyone, if you have any questions, big or small, to go ahead and put them in the chat. Thank you.
Okay, so what is patentable? So machines, we've seen, an example or two of that. So improvements thereof really can be for anything, machine, a process, article of manufacture. So that's sometimes referred to as maybe a product, compositions of matter. So especially with medications and a lot of the chemical inventions, compositions of matter are central to the invention, and so that's what's protected mainly in those patents. And then processes, so that can be a process for making a machine, a process for using a machine, a process for creating composition of matter, using it. Same with all of these processes really can apply to any of these. So as we mentioned before, there's no worldwide patent. And so you'll have to be careful in terms of your strategy. And this gives a little more information. So the United States is a first to file system, meaning if two inventors invent the same thing, whoever files the application first is entitled to that invention. And that's changed. We used to be a system where whoever invented first was entitled to the patent. And so sometimes that was a complicated endeavor to figure out who really was the first inventor. But now it's first to file. So even if you invented something first, if you waited 5 years to file, and in the meanwhile, someone else filed for that same invention, then that other person would be entitled to it. So, as soon as you are ready for that step in the process, you'll want to make sure to file your application. And it notes here, you'll want to make sure to file before public disclosure. And we'll talk in a couple of slides about why that matters. But in the US, there can be a bar to obtaining a patent if you've already disclosed your invention to the public before a certain amount of time has passed. And if you do only want US protection, though, as long as you file within a year of your public disclosure, you would still be able to file for patent protection. So that's one of the differences if you're thinking of filing internationally. So again, we talk about disclosure. So when you file a patent application, the examiners will, read through the application, understand the application, and then they'll look for what we call prior art. So we're trying to see, does the public already have this information? Would there be a detriment to the public to give someone a patent on this because the public is already out there using this information? And so prior art can be anything. It can be a publication. It could be a talk or presentation, a poster, even a movie or a video describing something. There was actually one examiner that used a YouTube video in a rejection of some claims. So really anything that's publicly available and it in some way commemorated, right? So if it's recorded or written or somewhere where it can be accessed, that can be used as prior art. So your own disclosure can be used as prior art against you if it's from more than a year before your filing date. And that's just sort of a, balance of fairness, right? If 2-3 years ago you provided all of this information and it's been out there in the public and so people have used it, maybe someone started making something based on that knowledge, then to come back, 3 years later and say, oh, never mind, it's mine now, right? That would be a great disadvantage to the public. So as long as within a year of your public disclosure, you file your application, then your own disclosure, won't be used against you when your application's being prosecuted. But some things you'll want to think about, if you are in a stage where, maybe you need to get some investment, you have this great idea, but you do need to tell some people about it in order to be able to, do the things that you need to do to pursue it. So you want to be careful about what you're saying before you file. And so that's, one of the reasons that generally at the office we recommend finding a patent attorney or a patent agent to help you once you've decided you are going to pursue protection. It's something that you can do on your own, and we'll get to the resources section where I'll show you some of the resources we have for people who want to file on their own. But just keep in mind some of the judgment calls that you may have to make about publicizing your invention and that sort of thing. You'll want to make sure that you aren't saying too much, and that can be kind of a difficult decision. But the easiest way is to make sure if you are making any public disclosures, you then file your application within a year so that you don't lose that ability. But can't I just keep it secret? If you can, it's best to keep it secret until you're ready to file. But practically speaking, often that's not really a possibility for people when they're trying to build a business. And so another thing I want to mention, a lot of us were not solo inventors. We maybe work for a large company, and many of you may already have patents, maybe listed on patents. So there is a difference between inventorship of a patent and ownership of a patent. So an inventor is someone who was involved in that process of, solving the problem, maybe identifying and solving the problem, and mentally figuring out how to contribute to that invention, that sort of mental process of invention. But that will not necessarily cause you to be the patent owner, particularly if, like most of us, you work for a company or for another organization. Generally, you have some sort of employment agreement, and so that requires you to, assign your right over to that employer. And so the owner of the patent then would be the company. And inventors cannot be companies, they have to be actual individual people in the US. And so, that's just a note if, when people are talking about ownership of a patent versus inventorship of a patent, there may be, many a person may have, many patents that they're listed as an inventor on, but they may not have ownership in those patents. And so this is just a little simplification of the path to a patent. So, there's the new idea, and within 1 year, you'll want to file an application. So this slide notes the difference between a provisional application and a non-provisional application. So a provisional application is sort of a way to hold the date for your eventual non-provisional patent application. The real heart of any patent is going to be a section called the claims. And the claims are where you really describe in detail what exactly the invention is. Well, a provisional application does not have to have claims. And the claims often are kind of legalese, they're written a certain way. That traditionally helps to clarify and capture exactly what's going on. But for the provisional application, you may not be there yet. You may have solved your problem, maybe you even have some prototypes and that sort of thing, but you're not really to the point where you're ready to get into the legalese and write exactly what this invention is. So for the provisional application, you can file just sort of the background section and some figures, and there's, I think, an oath and some other information that's required, but it doesn't require actual claims, and it's also not going to be examined. So that's not going to go to the examiner to determine whether or not you get a patent. But that's helpful because it gives you some time to then prepare your actual non-provisional application, which is going to be examined and which does have to have claims that, legalese, that's then examined by the examiner. So it's optional. You don't have to file a provisional application, but many people do because then that gives you, some time to kind of hone in on, how exactly to write your claims and what exactly needs to be in your non-provisional application. But that's not to say that the provisional application should be skimpy, because one thing that happens is the examiner will make sure that there's support in the provisional application for everything that's in the non-provisional. So while you don't have to have the claims, whatever background is necessary to explain your invention, whatever sort of practical steps are in your process, that sort of thing, you will want to have a description of that in your provisional application. And again, that's where, some of these concepts are, legal, based on legal precedents. And so they can get a little complicated, exactly how much do you have to say in your provisional versus your non-provisional. We have some courses that we offer for free that get into a little more detail about that. But that's also where, having a skilled patent attorney or patent agent to guide you can, help you avoid some mistakes that can end up being pretty serious. So this is just a simplified requirements for a provisional application. And so as I mentioned, it's there's some legal based requirements for how much detail you have to have in that provisional application. So that's what this USC 112 paragraph A. So that's a statute that's requiring that there's enough support in the provisional application to show that you really did grasp that invention, you really had solved that problem at the time you filed the provisional. Even though every little detail may not be there, there has to be enough there so that it's clear you had that knowledge and you had that understanding at the time you filed the provisional, and it didn't happen a year later when you filed the non-provisional. And then, the drawings and a filing fee and cover sheet are also included. And drawings I showed that one patent which doesn't require drawings. I would say the vast majority of patents there are drawings, but they're not always required. And so this recaps kind of a little bit what we talked about, intellectual property as a business strategy. Let me check the time here. So we just have a couple minutes. So I'm going to breeze through these a little bit, but a lot of companies and universities and organizations will have an in-house counsel or an IP counsel. And that's certainly, particularly if you work for a larger company, that's definitely where you'll want to start. If you think that you have something that may require patent protection, or you have an idea that lends itself to any of these forms of IP. So I'll stop there and see if there are any questions. At the end, I have just some slides about things that we have at the office to help applicants and just educate anyone who's interested on the patent application process.
I still see no questions.
Okay. Hopefully that just means I'm answering them all. But feel free. We're pretty much on schedule. So yeah, if you do have any questions, feel free. So, so this is just a screenshot of our main web page. It's actually one of the most user-friendly pages that I've encountered. We have it divided between patent basics and trademark basics, and there's some IP policy. So in patents, clicking through these different options really will show you pretty much all of the resources that we have available. I mean, if you go through all of these links, and there are many different phone numbers and organizations, that can help. But it's a great web page, and there's this Find It Fast here also has the most accessed links. So some of the things that people use most frequently, and I'll get back to some of those resources. But one of the things that you'll find in those pages is that we have relationships with organizations that provide pro bono legal assistance, and so that's free legal assistance. So here, California Lawyers for the Arts provides that in California. A lot of what they do is more focused on trademark and copyright, but there is a patents division where they do assist people who are filing for patent applications. And so this just lists, those regional programs across the country. And again, on our main web page, there's a link to that. We also have patent and trademark resource centers. So you can see there's a few here in California. They're usually in libraries, universities, and we have librarians there who've been specially trained to help people do, in particular, prior art searches, and to understand parts of the patent application, and what you need to do to get started with your search or your application. So they go through sort of like a little training academy, and they're great. They have a lot of knowledge. So for people who aren't near, one of our regional offices, but they really want to come in and talk to someone, we do have this network of patent and trademark resource centers. We also work with some law school clinics, so that's another link that you'll find in that information. And so usually that's where students, there'll be a faculty advisor, and students are, actually the ones that will help provide the assistance, help with writing applications and that sort of thing. And those are some great programs. So this was a joint effort with NIST. There's a inventor's assessment. So if you go through that assessment, it asks you some questions to help get an idea of what type of intellectual property protection you may want to pursue. And you get sort of a customized training material. So I put the link for that in there, which just, may be of interest for someone if you're, kind of not quite sure and want to see what suggestions that gives. So this is just a note that for smaller, so for solo inventors or for small businesses, for startups, there are discounts because, filing a patent can run into, just with the filing fees, I think are over $1,000. And that's not including, any assistance that you might get from a patent agent or patent attorney helping to write the application. So it can end up being a very pricey venture. So there are discounts for what we call micro entities, which, there's a definition for that here, less than 500 employees, has not been named an inventor in more than 4 previously filed applications, et cetera, et cetera. So there are definitely some benefits to filing for that micro entity status if you do qualify for that. So just to keep that in mind if there are any solo inventors out there. And then on the other hand, there's expedited examination if you just have extra money, because this also I think is $1,000 or so to apply for that. But the track 1 actually gives a faster examination than what a regular application would give. And I think our pendency now is about 18 months from someone filing an application to when an examiner picks the application up, or it may have come down a little to about 16 months. But with track 1 cases, that would be a much shorter time period to wait for that to be examined, because the entire round of examination generally has to be completed within 1 year. And so here at the San Jose office, this is a picture from obviously before the pandemic era, but we offered one-on-one meetings where you could reserve a time and talk with a patent specialist. This is a picture actually of our former regional director talking to someone in the office. And we can't give legal or business advice, other the most general sort of ideas that we have sort of like in this slideshow. But we can help identify, forms that you may need to use. We can give you background about, some like similar to what I've provided here about, when you would file a provisional, when you would file a non-provisional, the different types of IP. We also can help you with prior art searches. I mean, we can't do searches for you, but we can certainly help you use the tools that are available and identify sources of prior art, that sort of thing. So we still offer these in virtual format or as a phone call. So those are still available at all of the regional offices as well as headquarters. And here's just a list of, again, you can get to all these links from our main web page, but this is just a little list of all of them together. So there's also a application guide, which again, you can link through that main page. The assessment tool is there. We have some videos also for our Trademark Assistance Center. So pro se assistance, that's for if you're not using an agent or an attorney to help you file and you're filing yourself, that's considered pro se. And so that center is staffed with people who are experienced in helping people who are not, using an attorney or agent, because it can be very daunting, all of the different forms and the portal and, how to make sure you're really uploading everything that you need to. They can help with some of the practical aspects of that. And they can also help in responding to office actions. Once you file the application and the examiner is sending out an office action, they can help guide you through that process. And then there's a general helpline here too at the top. And that's it. So there's our Facebook and YouTube. We have a couple of videos there. In our Silicon Valley office, we offer trainings quarterly. We have a series called Path to a Patent where we start at the beginning of the quarter, and I think it's an 8-part series, kind of beginning to end of the filing process, application filing process. And we have, free web, everything's free. If you ever get something claiming to be from the patent office trying to charge you for any educational opportunities, that is not from us. Everything we do is free. But we have all sorts of seminars and webinars, from patent basics to foreign filing. We offer CLE for attorneys, if there are any of you that are attorneys. We have some higher level courses that are available for CLE credit, and kind of everything in between. And we also can tailor, if there's a certain group that's looking for information about a certain industry, or a startup that's at a certain point in the process, we can kind of tailor things for a different audience depending on their experience. So that's all I have. I guess I'll check again if there are any questions about anything.
I don't see any in the chat, but it's a small enough group, so if anyone wants to raise their hand, take themselves off mute. I have a backup question just to keep the conversation going.
Sure.
I'm curious, if someone feels like there's been a grievance or some sort of infringement, what are some of the first steps, like the first few steps they should take?
So if they've already received a patent and they believe that someone out there is infringing the patent, that's where they would want to get an attorney involved. So at the patent office, we have the examining court that deals with the applications and allowing the patents, but they're not involved in anything that happens after the patent is issued. But we also have the PTAB, Patent and Trademark Appeal Board. And so there are some things you can bring before PTAB to have. So sometimes both parties will have patents that are kind of similar or have some overlapping aspects. And so one thing that you might want to do is try to invalidate, or try to have that other party's patent invalidated. If you're saying, oh, well, you seem to be infringing my patent, and they're saying, oh, well, we have our own patent, then, it could be that one of those patents maybe is not, should not have been granted, or, there's some issue there with one of those patents being granted. So there are some proceedings that you can bring before PTAB, or there's, just federal courts. You can file lawsuits in a federal court, and there again, you'd want to get an attorney, certainly to advise you on that. The office doesn't really provide advice about, infringement lawsuits and that kind of thing. But there are some limited reviews that are available with our administrative judges.
Thank you so much. Did anyone else who's on the call have any other questions? We'll go ahead and give everyone their last 5 minutes back to get on with their day, but I'll stay on the line until 1. If anyone has any questions that do come up, we can also forward Jera's information if anyone wants to get in contact with her directly. And thank you again for everyone who's attended, and thank you so much, Jera, for the presentation. We really appreciate it.
Sure. Yeah, and we're easy to email at the patent office. It's our first name dot last name at uspto.gov. So feel free, if any questions come up, or there are any resources that you're looking for that you can't find on our page, feel free to email me, and I'll try to direct you in the right direction.
Thank you, and thank you, everyone. Have a wonderful rest of your day.